Perfect.
Let me just officially welcome Mr. Maximilian Zankel from the University of Graz for this lecture. Max, we are happy that you are here, not for the first time this year,
not for
a second time. You had also some time to enjoy the city, but this time you prepared for us an insight into actually your research, which you are, if I'm not wrong, preparing as a part of your doctoral project.
Yes. Yes.
So I hope that we will have some colleagues joining us online. At least, as I said, one colleague of mine, Professor Vitova, should be soon online. She was sitting at the doctor's, but she said she will be at least listening. So the floor is yours.
Thank you very much. Ladies and gentlemen, I'm very grateful for the opportunity to speak here today about my research topic. In this lecture, I would like to give a brief overview of the civil liability of politicians in Austria. The lecture is structured as follows. I would like to introduce myself briefly and then go into the topic mentioned. Here, I will discuss the following questions. Who are politicians? How are they liable, and what are the difficulties of this liability? First of all, allow me to introduce myself. My name is Maximilian Zankel, and I was given the opportunity to speak here today through a cooperation project between the University of Graz and the University of Olomouc. Last week, I had the chance to participate at the conference International Law, the Regulation of Resort to Force, Exhaustion, Destruction, and Rebirth. As I mentioned before, I'm from Graz, where I also studied at the Karl Franzens University, which is also the place where I work now as a postdoc assistant. The university is in Austria's second largest city, was founded in 1585 and is thus only 17 years younger than the University of Olomouc. The university currently has approximately 30,000 students and around 4,600 employees. On the top picture, you can see our old university building where only a few courses take place. Nowadays, however, graduation ceremonies and other events are being held there in this building. Next to it, you see our new library building, which was opened in 2020 and is quite impressive. I think Marco has already seen it live. And finally, below that, there's the building of our law faculty, which is currently home to approximately 3,600 law students. Our faculty is currently led by Dean Professor Christoph Betzemek. He is particularly committed in giving the faculty an international orientation. Professor Erika de Wet should also be mentioned. She has been at the University of International Law and International Relations at the University of Graz since 2020 and is also head of the institute. She was also the starting point for the latest cooperation project between the University of Graz and the University of Olomouc, together with Dr. Marko Svicevic and Professor Feix. Lastly, I would like to mention my current supervisor, Professor Bernd Wieser, who is also supervising my PhD thesis. His main areas of focus are in the administrative and constitutional law, as well as in the comparative constitutional law. He is Vice Dean for Academic Affairs at the faculty, and beyond that, he has been head of the Center for Eastern European Law at the University of Graz since 2015. He was once a visiting professor at the University of Olomouc and has had a personal connection to the University of Olomouc since the early 1990s, when he and Assistant Professor Dr. Armin Stolz held a seminar on comparative constitutional law and thus visited the faculty of Olomouc annually. Now, however, let us move away from personal matters and begin the professional aspect of this lecture. My research project is entitled The Civil Liability of Politicians, and thus finds itself in the interface between the public law and the civil law. Often, politicians act carelessly and cause damage to others. For example, there was the case of a boy who was seriously injured by a fish in a municipal lake. As a result, the mayor was sentenced to pay compensation to the injured boy. Other examples can be found, in particular in connection with laws and regulations in the pandemic, which also harmed many economically. In the latest case, compensation was denied by the Austrian Supreme Court for the mistakes of the Minister of Health in this context. A current case can also be found in Germany. There it is currently being discussed whether the former minister Scheuer is liable for the damage to the Republic, which resulted from the fact that the troll project was cancelled after it was judged to be illegal by the European Court of Justice. The damage was caused to several companies that have already taken action in this context. Apart from this, there are many other cases. Comparable cases certainly also may exist in the Czech Republic. However, it is noticeable that reports about claims for compensation against politicians in person are the exception. Therefore, I want to deal with the legal framework of such a personal liability within my research. Before considering the actual liability, it is necessary to consider who politicians are. In Austria, there's no law that addresses politicians and therefore defines that term. There are several approaches about a definition in various sources, but I have decided to choose my own. Basically, the following persons can be subsumed under the term politician. Politicians without an office who are regularly active in electioneering, organs of the legislation, and administrative organs. I have excluded the first group, the one on the left side, from my concept of politicians. But why? For me, politicians who are not in an office do not have the necessarily close relation to the state. My main concern is to examine how to deal with damages to the state, the general public, and finally to the taxpayers. For this group of people, liability-based circumstances, such as insults during the election campaign and so on, are conceivable, but they do not fit in the objective of this investigation. The next group highlighted are the organs of the legislation. These organs are immune in Austria. Immunity provisions are found in the federal constitution for both the federal and the state legislative organs. The only exception how liability can nevertheless arise is so-called state liability according to the case law of the European Court of Justice. As shown in the Frankovic case, state organs and also organs of the legislation are liable for violation of union law. A conceivable example would be the incorrect implementation of EU directives into national law. Since these organs are only exposed to liability in a very narrow field, they too will not be examined here. I want to focus only on the third group, the organs of the administration. These are not immune in Austria and probably have the closest relation to the state. On the next slide, we will briefly explain which organs these are in concrete terms. As already mentioned, we focus exclusively on the administration. The Austrian administration is divided into three levels, as we can see here: the federation, the states, and the municipalities. And at all levels, there are bodies that are entrusted with the administration. I have included the following organs at the different levels in my definition of politicians: the federal president, who is not immune in Austria as he is in the Czech Republic, the chancellor, the vice chancellor, ministers, the federal state secretaries, the state governor, other state councillors, the mayors, the members of the municipal council, and members of the municipal executive board. This list may seem arbitrary at first, but I have a clear feature here why these bodies were chosen. It is to include those organs that are able to carry out certain administrative agendas independently and without instructions from others. So they are the highest in the system of administration at their level. In principle, one could understand the term liability to mean several things, namely criminal liability before the criminal court, political liability to other organs, or even liability before the constitutional court. However, I'm only concerned with civil liability. It's therefore purely a question of compensation of damage. This form of liability is already provided in the Federal Constitution of Austria. Article 23 of the Federal Constitution of Austria itself provides for a so-called official liability. According to Article 23, paragraph 1, the federation, the states, and municipalities are liable for damage caused to a third party by an organ acting on their behalf in the execution of law. If the legal entity, these are the federation, the state, or the municipality, has compensated for damage, it can claim the damage back from the acting organ, if the latter has acted with gross negligence or intentionally. Paragraph 3 still provides for liability of organs that damage the legal entity in execution of law directly. Both forms of liability are only fundamentally prescribed in the federal constitution. They are to be implemented in detail by simple laws. The legislator has done this with the Public Liability Act with regard to paragraph 1 and 2, and with the Public Officers Liability Act with regard to paragraph 3. Both forms of liability only cover acts in the execution of law. On the one hand, this means sovereign acts. We will return to those within the framework of private sector administration later. And on the other hand, it limits the liability to organs of the administration and jurisdiction. Legislation is not covered. This system of liabilities is not entirely uncomplicated, which is why we will look at it again on the next slide with graphic representation. I think in some aspects, this system can be compared with the rights stipulated in Article 34, paragraph 3 of the Czech Charter of Human Rights about the compensation of damages caused by the state. Maybe we can talk about this later. So now on the left side, we can see the construct of liability by the Public Liability Act. Remember on the slide before, this was Article 23, paragraph 1. And on the right side, we see the construct regulated by the Public Officers Liability Act. Remember on the last slide, this was paragraph 3. Let's start on the left side. This means that we have an organ, here it is our politician, we have an organ of the legal entity, whether this is appointed, employed, by contract, or however is irrelevant. The organ harms a third party within the framework of the execution of laws. The harmed person has no possibility to take direct action against the politician. They have to file a claim against the legal entity. This is good. This is a good starting point for the harmed person, as the legal entity is a much better financial position than the organ. Only when the legal entity has paid compensation to the harmed person, it can claim recourse from the organ under certain conditions. And we will talk about this recourse later. In contrast, the Public Officers Liability Act provides for a different case. It applies to cases in which the organ does not harm a third party, but the legal entity itself. In this case, the organ can be directly liable by the legal entity. Let us take a look what the prerequisites are for the liability to arise. These are regulated in the same way in both laws. We will look at the Public Liability Act as it is more relevant in practice. The law provides for liability in accordance with the provisions of civil law. This means that there is a comprehensive reference to this general civil code. Thus, the legal entity is liable according to the provision of civil law, with a few special features provided in the Public Liability Act. The prerequisites for compensation are, in essence, that there must be a compensable damage, that the damage must be caused unlawfully and culpably. On the next slide, we will look at what problems this actually brings. In my opinion, this is also a major difference to the system in the Czech Republic, as in Austria, culpability on the part of the body is necessary, but not in the Czech Republic. As already mentioned, paragraph 1 of the Public Liability Act stipulates that organs cannot be held directly liable. And there is another special feature compared to the general compensation of damage under the civil law. In general tort law, the principle of restitution applies. This means that the original condition is to be restored, and only if it's not possible, the damage is to be compensated in money. There's no possibility of restoration in the Public Liability Act and in the Public Liability Law. But why? This has a constitutional background. If the law were to allow the possibility of restitution, it would be possible for organs of the justice, namely the judges, to prescribe certain actions to the organs of the administration. This would thus constitute a kind of instruction which would not be compatible with the principle of the separation of powers in the federal constitution. Now let us look at the difficulties associated with the prerequisites for liability, especially in public liability law. According to Austria's tort law, a distinction is made between two types of damage. On one hand, damages in absolutely protected legal goods, on the other hand, pure economic loss. Absolutely protected legal interests are legal goods that the legislator places under special protection, such as property, physical integrity, or personal rights. Pure damage of economic interests is not included. Damage caused by politicians, however, is in most cases precisely such a damage. An exception would be, for example, if a politician causes an accident on the way to official appointment and injures a third party. But this is not the standard case. In essence, however, individual cases will be purely economic loss. These financial losses are only compensated under certain conditions, namely if there is a contractual relation between the damaging party and the injured party, or if there's a protective law that aims to protect against this specific damage. In our case, a contract never exists between the politician and the injured party. This is due to the fact that as soon as there is a contractual act, it's no longer part of the sovereign administration, and therefore this type of liability doesn't even apply. Furthermore, there is no contract between the legal entity and the politician that can establish a liability, as these politicians are not employed by contract, but are regularly appointed. Thus, in the end, the only liability that remains is the one resulting from the violence of a protective law. However, there is very rarely one with the aim of protecting the individual from financial loss caused by such an organ, which is why liability often fails here. In the context of officers' liability, which provides direct damage to the legal entity, this is not quite so dramatic. The aspect of negligence must also be given a special consideration, in this case of politicians' actions. The actions that politicians take are not fully comparable to actions of other people. They are often preceded by a long process and are often the result of a political agreement. Furthermore, the field of activity of politicians must be taken into account. Especially at the municipal level, mayors in small municipalities, for example, regularly perform their duties on a part-time basis, but are entrusted with the same municipal administration tasks to the same extent. They range from spatial planning to matters of building law to the agenda of organization of the municipality. The last difficulty on this slide, and probably the biggest one, will be mentioned on the next slide because we will take a closer look at it. We have already mentioned several times that there is no direct claim to the organ within the framework of the Public Liability Act. Only the legal entity can be claimed against. However, if the legal entity has compensated the injured party for the damage, it can take recourse against the organ, which is the politician in our case. This is also provided in paragraph 3 of the Public Liability Act. However, this is subject to the condition that the acting organ has acted intentionally or at least with gross negligence. In case of slight negligence, there is no possibility of a recourse and the legal entity alone has to bear the damage. This claim is quite comparable to the claim under the Public Officers Liability Act. With both of them, both of the claims, there are also the possibility of the moderation by the judge. These two claims are essentially the only forms in which organs can be personally liable for their legal entity within the framework of the sovereign administration. However, for this to happen, the claim must also be enforced by the legal entity. This is done by organs appointed to represent the legal entity. Within the framework of my project, I have looked at who is responsible for the enforcement of such claims. And I've looked at it at the different administration levels. I don't want to go too much into detail about the Austrian administrative organization, but rather highlight the results of this. In most cases, organs that are politically connected to the damaging organ are responsible for enforcing these claims. For example, the governor of a state is responsible for enforcing the claim against another state councillor. And those two are regularly in the same party, or at least connected to the same party through a coalition. At the federal level, in my opinion, the individual ministries are responsible for taking action against the injuring organ within their sphere of influence. So a minister would have to take action against himself. And let's be honest, would you sue yourself? Probably not. And that's the big problem here. Let us conclude with the area of public administration. In the following, I would like to briefly discuss the area of private sector administration, since liability issues are often involved here as well. I do not want to illuminate this part of liability in its entirety, as this would be far too extensive. However, to give you an overview, I would like to give a brief insight here. In contrast to the sovereign administration, private sector administration refers to the area of administration in which the organs act in forms that are not reserved for the state, but are available for everyone. A classic form is the contract, for example, in the areas of funding or administration of public property. The aforementioned legal basis, namely the Public Liability Act based on Article 23 of the Federal Constitution and the Public Officers Liability Act, are not applicable in the area of public sector administration, since it is not a matter of the execution of laws. Thus, the special features of this area of application do not apply. In the context of the private sector administration, direct claims to the organs are possible, and compensation is not limited to money. However, the question of the protective law also arises in the case of pure economic loss. Furthermore, the question of the enforcement of those claims in the area of private sector administration is quite similar. Let us come to a summary and outlook what could be possibly improved. Based on the system presented, it can be deducted that there is a system of liability of politicians in Austria. The system is already outlined by the Federal Constitution and is regulated in detail by two implementing laws. Demands from the society and the media for the liability of politicians are therefore at least partly unfounded. Within the system, there are two ways in which politicians can be personally. On one hand, in case of direct damage to the legal entity within the Public Officers Liability Act, or in case of damage to a third party within the recourse by the legal entity under the Public Liability Act. However, this is also where we have the biggest problem located, namely the competence to enforce such claims. As a rule, the competence belongs to an organ or to organs that are politically connected to the damaging organ in such a way that the enforcement of such claims is the exception. This could be improved by shifting the competence to an independent institution. This would have to be an institution that is independent and thus has no personal or political relationship with the respective organs. Such an attempt has already been made. The member of the parliament and later candidate for the office of the federal president, Dr. Univ Ass, introduced a draft law in the National Council to provide for a subsidiary competence of the Court of Auditors to assert such claims in the Public Liability Act and the Public Officers Liability Act. I've taken a closer look at this proposal, and in my opinion, it would not be possible to do it in the proposed way. Let's see why. The Public Liability Act and the Public Officers Liability Act are simple laws. The doctrine is of the opinion that the competences of the Court of Audit are conclusively regulated in the Federal Constitution. A new competence in a simple law would therefore not be compatible with the Federal Constitution. It would require an amendment of the Federal Constitution, and this would mean the approval of 2/3 of the members of the National Council, with 1/2 of them present. So it would need a higher degree of political will to make the liability of politics more stringent. In my opinion, other forms of assigning the competence to another institution always end up in an amendment of the Federal Constitution. Thus, it all ultimately takes a great deal of political and democratic idealism to bring about a more effective form of liability. Whether this will happen remains to be seen. Thank you very much.
Thank you, Maximilian. I think it's time for questions. I don't know whether we have any questions. Who is online? I saw that there was some 3-4 people following, so I don't know how many remains and how many are still there. It's on. Yes, it is on. So I don't know. Are there any questions from the online participants? We can stop sharing. No, I don't see.
Yeah, okay. No one is forced
no.
to ask them.
Any questions from those sitting here? If not, then I have a question. And maybe I was thinking about the very first substantial slide you have, or you had presented, and that's the definition of a politician. What I was just thinking of is how well, let's say, this kind of definition can capture the reality if you look, for example, to Poland, where Mr. Kaczynski, for actually quite a long time, was definitely the person deciding on what's happening in Poland. Nevertheless, he was not holding any kind of office, no official position. Nevertheless, all the persons, including the prime minister, went to his flat or house to get his decisions on what's going to happen. Of course, I fully understand that this is something which is in terms of a system, not how it should be, that it's outside of a system, how it should function. Yeah. Nevertheless, this is sort of a reality. And if we look around in Europe, maybe it's not just the case of Poland. So I was sort of just thinking how, let's say, accurate and how encompassing this kind of definition is, because this is, and I fully agree, this is basically the starting point of your considerations.
It is, and thank you for the questions. Quite interesting question. I've never thought about this in that way, but I think wherever you look, it must not always be the state. It can also be a big company. There's always a person that has to decide, and it doesn't matter where his will comes from and what he decides. It's only up to this person to decide it. In Austria, we have some rumors as well that the wife from the chancellor has a big influence on his decisions. But in the end, it's the chancellor who is alone responsible for taking those decisions, and in the end is liable for this.
Yes and no. Of course, the wives can do a lot of things. If we say that the man is the head of the family, the ladies are the necks moving the heads very often. But we have, for example, in international law, you have still the concept of, for example, when we are talking about international responsibility, you have the concept of de jure organs, but also of de facto organs. So we recognize by law that it's not always just the official position or the one being in an official position in a situation in which then which can incur international responsibility. And that's what I'm talking about. Of course, I fully recognize that there is a lot of moments and background things which influence the situation, and of course that we cannot. It would lead us ad absurdum to invoke the responsibility of everybody who is participating in any way. But as I said, if you look at this concept, we do have actually the concept of the so-called de facto.
This is a pretty interesting thing, especially if you think about how political decisions are made. If a mayor in a small municipality can also be influenced, let's say, by the party or by the head of the party, which must not be a politician in my definition. So this is the distinction between de jure organs and de facto organs is a pretty interesting approach, and I will read something about it. Maybe I will use that. That's very interesting. Thank you so much.
And then maybe, thank you. And then just for clarification, I was not maybe catching completely properly what you were mentioning, the problem that the minister would have to sue himself. So if you just can clarify this.
Yeah. If the legal entity wants to recurse the compensated damage from the organ, someone has to file the claim. There must be an organ that is in charge of doing that action. And I've taken a look at the system and whose competence is it to enforce such claims, and it's the minister's competence for the whole ministry and all the organs apart from it. But it's also the minister's competence for the minister himself, and that's the problem. So the minister would have to sue himself if he is the damaging organ in a concrete case.
Which, okay, I agree that what you are saying, but at the same time, we have to consider that we are not talking about the minister as a physical individual person, but rather the minister as a position, like is a amtliche Stellung. So actually, it's not the minister sues the minister, but it's like the office of the minister, or however you call it.
Sues the minister in person.
Which is nothing like special. There can be probably other cases when this could like happen. And so I understand that this is a problem, but this is quite a regular thing. And I'm sorry, since I'm international lawyer, so I just think again, it's a very similar thing, for example, with international organizations. If you think about damages within international organizations, so basically, since there is no forum in which you could sue an international organization as such, actually, then the only recourse you can have is to ask an organ, if there is one at all, in the international organization, and file a claim with them, and then it's the organization deciding by itself on its own misconduct or not. So you have a lot of this kind of.
But if you only consider the national law, it's a pretty unique thing. That's the point here.
No. I understand. No, sure. Okay, that's it. Thank you.
Thank you very much.
All right. If there are no other questions.
Oh, Max, I would like to actually ask you, and maybe not substantively, but is there a specific reason that you came across this topic? What made you decide to focus on this topic?
What made me decide? When I started at the university, I fell over this topic by some circumstances, and I read something about it, but it was a political statement. It was not a scientific text. And then I did some research on this liability, and there wasn't quite nothing about it. No one ever touched this topic because it's like no one wants to burn his fingers or something. And that caught my attention. And so I talked to my supervisor if this would be a topic that I can do my research on. And she said yes. And so the whole project started 2 years ago.
It's an interesting topic because in the Czech Republic, at least one party, not a very democratic one, but still one party is pursuing or pushing a lot for, let's say, the material liability of politicians. I'm not sure what's their concept or how exactly it would differ to what we have, but I just know that they made it a huge topic in several elections already. So apparently it is a topic also among the politicians.
But very interesting. If you see some English papers or even German papers on this topic about the Czech Republic, maybe you can send them to me, because I did some research and I couldn't find any English or German texts on this topic in the Czech Republic. So I worked with some translation apps.
Well, it would be probably, or most probably, or let's put it this way, I don't know how seriously these suggestions have been elaborated in, let's say, in legal terms, but it is certainly one of the main points which they are presenting. So I guess there is some background. So we are certainly able to send you. Peter just found the webpage of the party.
It's a SPD party. It's a populist party. So and they suggest personal, let's say, material and criminal responsibility of politicians, but very often they suggest things just to go against the stream. They also suggest their democracy and things which on first sight look great, but they are not really democratic party.
Okay, I see. Yeah, that's the other.
And the question is also how it all fits into the existing legal order, because so that's why I'm not aware completely what exactly they mean by these terms, because one thing is of course what you proclaim as a political party, but what is then meant in real terms. So how they would, I'm not also sure whether they actually, I thought that there was also some already suggestions for legislative acts on this kind of stuff. So if we come across this, we might be able to send it to you. Thank you, Max.
Thank you very much. Maybe I have to put this off. I have no idea how it works.
It's the button on button on the bottom of the microphone.